Hello and welcome to today's webinar entitled Pathways to Permanent Residence for Migrant Workers. My name is Sabrina Dimitra and I'm AMSSA Settlement and Integration Program Manager, and I will be facilitating today's event. But before we get started, I would just like to acknowledge and thank the Government of Canada's Migrant Worker Support Network for funding today's event. And so now I'd like to introduce our presenter team, who will be presenting as a team today. And so our first presenter is Will Tao. He's a lawyer with the Edelman and Co. Law Offices. And Will is a Canadian immigration and refugee lawyer. He provides legal services in all areas of Canadian immigration and refugee law, with a focus on complex refusals, appeals, and judicial reviews. Within the foreign worker context, Will exclusively addresses temporary foreign workers and focuses on pathways to permanent residency and temporary resident status issues. His law blog, Vancouver Immigration Blog, recently won a 2019 Best Law and Commentary Blog in Canada award. So thank you so much to Will for joining us today. And we also have two second-year law students from the Allard School of Law from UBC, Karen Jansen, who is a second-year law student, and she's interested in immigration refugee law. And she's been a part of the Law Students Legal Advice Program, Pro Bono Students Canada, and the International Justice and Human Rights Clinic at UBC to learn more about this area. She's also worked at the Victoria Immigrant and Refugee Centre Society. Well, thank you for joining us. And our second law student who's joining us today is Atitwa Tapa, who is also a second-year law student at UBC. As a student volunteer with the Student Law Legal Advice Program, Atitwa has assisted clients on a wide range of legal issues like residential tenancy, human rights tribunal, criminal trials, and immigration cases. Will, Karen, and Atitwa are presenting today on behalf of the Law Students Legal Assistance Program, the Allard School of Law, UBC. And our final presenter, who's part of the presentation team today, is Juliana Dolly, who's a staff lawyer with the Migrant Worker Center. Before joining the Migrant Worker Center, Juliana worked as an immigration and refugee lawyer in Vancouver, where she helped people with many kinds of immigration issues, including family sponsorship, work permits, provincial nominations, and permanent residency applications. Juliana has focused her legal advocacy on advancing the rights of migrant workers, and she has represented many migrant workers in legal proceedings to uphold their rights. So we have a very knowledgeable team who will be leading the content of today's webinar. And so I'd like to hand it over to our speakers to guide us through the webinar. Well, thank you so much.
Thank you, and good morning, everyone. I want to first start by acknowledging that we are on the traditional, unceded, and stolen territories of the Coast Salish, Tsleil-Waututh, and Musqueam nations. The lands upon which we are giving this talk were unceded, meaning they were never given up. These lands were taken. We acknowledge the harms that colonialism continues to do and recognize that our work of immigration and doing this work as settlers within a deeply problematic framework is a foundation that we need to continuously acknowledge and settle. So let me first start by telling who we are. At UBC's Law Students Legal Advice Program, it is a nonprofit that is run by law students at the Allard School of Law. We get thousands of clients each year where we assist them with immigration, criminal, human rights tribunals, residential tenancy, and other small claims issues. And at the Migrant Workers Center, they're dedicated to legal advocacy for migrant workers in British Columbia. To provide you with a brief outline, we will first tell you about what the BC Provincial Nominee Program is. And if you're from other provinces, then I mean, they might not be applicable directly, but a lot of it will be similar. We will also talk about the Caregivers program, the Agri-Food Immigration Pilot Program, the Municipal Nominee Program, which is a new one, and Humanitarian and Compassionate Applications, a few takeaways and some question and answers that you might have. I also want to start by saying that today's presentation is focused on low-skilled migrant workers. We acknowledge the socially constructed barriers between skilled and unskilled, and that ultimately this is a challenging label created by our current system. Some of the categories will dovetail with skilled work, yet the presentation will highlight that the limited permanent residency options for low-skilled workers leads to precarious lives and realities.
So the first program we're going to talk about is the BCPNP, Provincial Nominee Program. And it's a provincial economic immigration stream for high-demand foreign workers. If you're eligible for one of their programs, the process is that you create an online profile, which is free, and then you receive points for the information that you enter, and you're entered into a selection pool for your category, where you're ranked alongside all of the other registrants in that category. And then periodically, the BCPNP program will invite the highest scoring registrants from each category to apply. And then if you do get invited to apply, it's a $700 application fee. And then if your application is approved, you receive a nomination to apply to the IRCC, the Immigration, Refugees and Citizenship Canada federal government's immigration program for permanent residents. You must maintain the conditions of your nomination while you're waiting on that decision. So they have a, it's called low skilled options, or it's called the entry level and semi-skilled program, which is for lower skilled immigrants. And you may be eligible for this category if you're currently working in the Northeast Development region of the province, which is on that map, in any entry level or semi-skilled occupation other than caregivers, listed as C or D in the National Occupation Classification Codes of Jobs. There's a special program for caregivers that we'll discuss after this. If you are not working in that Northeast Development region, but anywhere else in the province, then this list, it's very small on here, but you can also find it on their website, has the only National Occupation Classification level C or D positions that will make you eligible for this category. So in terms of eligibility, your BC employer must have offered and you accepted a non-seasonal full-time offer of employment in BC. And that job offer must be signed and dated by an employee or the owner of the company who's authorized to hire employees. You also must be qualified for the position. And so the BCPNP program may refer to Work BC or industry standards to determine what the minimum qualifications for an occupation are. And if the position requires mandatory certification or registration of any kind, you must also provide documentation when you apply, showing that you meet those requirements. Also, the wage that you've been offered must be competitive with BC wage rates for that occupation. And when you apply, the onus is on your employer to demonstrate that it's a genuine wage that you are offered. Applications won't be approved if the BCPNP believes that the wage you're offered has been inflated or increased for the purpose of meeting minimum income requirements or to obtain a higher registration score. If you're working for your BC employer on a valid work permit, you must be able to demonstrate a history of earning that offered wage before you submit the registration application. It would be very helpful if you save your pay stubs and if you have any gaps in your employment, providing an explanation for that. If you were originally hired on a labor market impact assessment, then the wage you're earning at the time of registration should be equal to or greater than the wage stated in that LMIA. Your employer also has some eligibility requirements. They must be in good standing and have a business structure that's either incorporated, registered as a limited liability partnership in BC, or be an eligible public sector or nonprofit employer. Your employer must be permanently established in BC as defined by the Federal Income Tax Act. They must have operated in BC for at least 2 years. Your employer must also have a history of good workplace and business practices, including complying with all applicable BC and federal employment, labor, immigration, health, and safety laws and regulations. Your employer may be asked to provide financial statements. And under provincial regulations, it's important to remember that BC employers are required to have WorkSafe BC coverage for their employees. That's something that they may check on. If your employer is located within the Greater Vancouver Regional District, your employer must have at least 5 full-time employees in BC. And if they're outside that region, then they must have at least 3 full-time employees in BC. Only individuals who are on the company's payroll will be considered employees of the company. Your employer must also issue you that written offer of employment, complete the employer sections of the application forms, and notify the BCPNP if there's any changes in your employment status, like if you've been demoted, terminated, laid off, on extended leave, or if the business changed ownership. You must be employed and work full-time, so that means at least an average of 30 hours per week year-round with the BC employer who's supporting your BCPNP application for at least 9 consecutive months immediately prior to registering for the BCPNP. Employment that's part of a study program like a co-op or that you get using a study permit doesn't qualify towards your work experience. For the purposes of assessing your work experience in Canada, the BCPNP will only consider work experience that was obtained while you were legally authorized to work. In addition to the 9 months of full-time employment, if it's a long-haul truck driver position, they must also have 2 years of employment experience as a long-haul truck driver in the 3 years before registering. And that experience can be from within Canada or abroad. You also must, at minimum, have successfully completed secondary education within or outside of Canada. So you'll need to submit a copy in English of your highest level diploma, certificate, degree, or transcripts. You must also demonstrate proficiency in French or English at Canadian Language Benchmark Level 4, and you'll have to provide a copy of your language test. Another requirement is demonstrating that you meet minimum income requirements from your family income, which is your annual wage from your employer, and if your spouse has authorization to work, their annual wage as well. And for the purposes of calculating family size, dependents who are Canadian citizens or permanent residents are not included. And the BCPNP must be informed of any changes to your family size throughout the application process. Any changes to that could affect the minimum income requirements. And you must be able to demonstrate a history of meeting the income threshold requirement for the full 9-month period prior to submitting the registration. You must inform the BCPNP if there's a change in your circumstances, like a change of employer, change in salary, change in job title, number of dependents, or change in immigration status. And you must maintain full-time employment with that employer throughout the process. You will not be nominated by the BCPNP if you're prohibited from entering Canada, if you're in Canada and out of status, if you're working without authorization, if you have an unresolved refugee claim in Canada, or if you're under a removal order. And it's quite likely that the BCPNP will check to verify each of the requirements. They may confirm that your employer meets all of those eligibility requirements, confirm that your job consists of the duties that you say it does, call your workplace to confirm that you're working there, and calculate your wages to ensure they match with the prevailing rate, are above minimum wage, and are in accordance with BC employment standards. In general, the lower skilled the work, the more scrutiny you and your employer will be under to make sure all the requirements are met. This chart has a breakdown of how the points are awarded. And if you have a registration score of 95, that means you're guaranteed to receive an invitation to the next round. And the BCPNP website lists when the most recent rounds of invitations were offered, along with those scores, so you can kind of get an indication of what the average is at the time. But the number of scores and the frequency of invitations is always subject to change, since it's based on annual nomination allocations and program capacity for processing.
So we wanted to provide you with a case example just to illustrate some of the principles and factors that Karen has just reviewed. So in this example, Anita, a theoretical client, came to Canada as a caregiver. She has a spouse and a child in her home country. She received an open work permit for vulnerable workers, valid for 1 year. She gets a job as a front desk clerk for a hotel. She is paid $17.50 per hour, and after 9 months, her employer offers her a full-time permanent position. She has 5 years of work experience in the hospitality industry in her home country. She has a Bachelor's of Commerce degree, and she took the IELTS test and got a CLB 6. So the first question is, does she qualify to apply to the BCPNP for a nomination? And the second question is, is she likely to receive a nomination given the factors that we have outlined? So with respect to the first question, she meets the requirement of having a job offer that's permanent and full-time in one of the listed occupations for the low-skilled, entry-level and semi-skilled program. She has 9 months of work experience. She's paid $17.50 per hour, which we can assume is meeting the minimum wage requirements and the prevailing wage requirements for her occupation. She also meets the minimum income requirement given her family size. And we can assume as well, although the information isn't there, that her employer meets the requirement of having the requisite number of employees. Now, what we don't know is where in the province she's working. If she were working in Vancouver, her employer would need to have 5 employees, and if she were working outside, there would need to be 3. But in any event, so I think she probably does qualify for the BCPNP given the information we have here. She has a valid work permit, valid immigration status. But then the question is she likely to receive a nomination? And given the factors that we've outlined, basically the score that she would be getting would be probably around the 70 to 80 range, depending on where she's working in the province, and depending on if she has the work experience directly in the specific occupation that she has been offered the job. So that's a really important factor, and BCPNP will scrutinize that. But assuming that she does, she would probably be getting about 70 to 80 points. And given the scores that we are seeing most recently, it's questionable whether she would or wouldn't get an invitation. She might have to wait in the pool for some time before the scores go low enough. So it really illustrates we have someone here who's making she's making above minimum wage, she has higher education, she has good language skills, and yet it certainly isn't a guarantee that she would get an invitation to apply. So it is, this is just to highlight that even if someone does meet the minimum requirements, it's not a guarantee that they will get an invitation to apply. So we wanted to review a few best practices for BCPNP applications and highlight a couple of the pitfalls. So first, it's really good idea to get legal advice about eligibility before registering and embarking on this process. So if the client applies under the wrong category, for instance, or they apply with the wrong job classification, this can be a challenging and costly problem to fix. So it's a good idea to get advice at the outset, and really to understand the different occupations that are listed under this program and what specifically they are, the occupations involve. So later in our PowerPoint, we've included an introduction to the National Occupational Classification, or the NOC. This is a classification system that the government uses for different occupations. So we won't go over that in the presentation, but it's just to highlight that and ensure that the client is aware of what the minimum requirements for their occupation are and what the job duties are, and the description. So another thing that we wanted to highlight is that it's really important for the client to list their work experience accurately. some of the kind of common problems that we see are folks failing to list part-time employment as part-time, which can impact on the scoring and the level and the amount of points that they would get. So again, that's just really important to get correct from the outset. Related to this, it's really important to ensure consistency between the PR application that's going to eventually result from a successful application to the BCPNP and with the underlying PNP application itself. So that's one of the things that, even if someone is successful in getting a nomination from the province, they're then going to have to go on and apply to IRCC for permanent residence. And IRCC is going to scrutinize really carefully, things like the work history, the family composition, that sort of thing. So it's important to get these things right from the outset. Now, as Karen mentioned, you do have an obligation to inform the BCPNP about changes in employment status and other factors while the application is ongoing. And I did want to note that, it's not necessarily going to be fatal to the application if there is a change in employment. And so it's really important that people get proper legal advice in a timely manner if there is a situation of job loss, because people might be afraid to let the BNP know that because they're afraid that they're going to lose their nomination. But it is really important to make that disclosure in a timely manner. And there are solutions such as applying to change the conditions of a nomination if the individual can get a job offer elsewhere. So it's really important that people get advice in those situations. And finally, the last thing we wanted to note is to just be aware of issues such as fraud or exploitation. So if you're seeing clients that are, in situations where the job listed in their application doesn't seem to be the job that they're actually doing, or the wage that's listed in the application and on their pay statements is one thing, but actually in practice the client is required to pay back a portion of their wage to the employer. Unfortunately, we do see these things happening, and those are situations where you absolutely want to refer the client for legal advice, so that they can get the assistance that they need to resolve the situation, and potentially make a complaint against the employer if appropriate. It is really dangerous waters, and there are unfortunately situations where people are falling victim to fraud, and that can jeopardize their status in Canada. And just to briefly note, these are some of the documents that you want to make sure you have ready, or at least you're working on at the time that you register. So, you want to have identity documents and proof of your status and education credentials. Getting an education credential assessment done can increase your points, but these can be lengthy to obtain, so it's a good idea to start early. Taking the language test, sometimes people may need to take it a few times to get the score that they want, so taking that into account early on. And then there are several documents that the employer is going to need to complete and fill out, including an offer form that's created by the BCPNP, a job offer letter that's signed on their letterhead, a reference letter explaining why this individual is going to be an exceptional asset to the business, job description, pay stubs, and proof of incorporation and a business license for the employer. So it's a good idea to get these documents ready early.
The next program we'll be talking about is the Caregiver program. This has undergone a lot of change. So right now we have the Home Child Care Provider Pilot and the Home Support Worker Pilot. They let qualified caregivers and their family members come to Canada with the goal of becoming permanent residents. If you have a job offer in Canada as a caregiver, or if you already have experience working in Canada as a caregiver, you may be eligible. Qualifying work experience means that you have worked full-time in either the home child care provider NOC position or the home support worker NOC position, but not as a housekeeper. If you have no qualifying work experience, you can apply if you meet the other eligibility requirements. Apply to either program, depending on which occupation you plan to work in. Submit a work permit application together with an application for permanent residence. If you meet the requirements, you'll get a work permit, and this work permit will be occupation restricted, so you can work as a caregiver for any employer. Once you have at least 24 months of work experience to qualify for permanent residence, send in proof of the work experience, and a final decision on your permanent residence application will then be made. Your family members are also eligible to accompany you to Canada and can work or study. You must have a valid job offer for full-time employment from a Canadian employer outside of Quebec, be qualified for the position, prove Canadian Language Benchmark 5 abilities, and have completed at least 1 year of the equivalent of Canadian post-secondary education. If you don't have 12 months of work experience, but you have some, you can apply to this program to complete your work experience or keep working on your current work permit until you have 24 months of experience. Your qualifying work experience must be in one of the jobs and not a mix of both, but it can be for multiple employers. If you already have 24 months of qualifying work experience, you and your family members may be eligible to apply for permanent residence, as long as you include documents to prove that you have that work experience. Your 24 months of full-time work must have occurred in the 36 months before you apply. All the other requirements are the same.
So again, we just wanted to review some of the best practices and common pitfalls that we see in our practice. So one of the first things I wanted to highlight is that it's a great idea to really encourage you to refer your clients to attend a workshop with the Migrant Workers Center on applying for permanent residence under the caregiver programs. We offer these workshops every few weeks, and we go into in detail the requirements for the eligibility, the type of documents that are required, instructions on how to fill out the forms, and best practices. So this can be really helpful for clients to really understand the process. Our next workshop is going to be held on March 14th, and so we encourage you to contact our office if you have clients or if you're interested in attending. The other thing to note is to begin gathering documents early. So some of the requirements that Karen reviewed, such as obtaining an education credential assessment and completing the language test, can be very lengthy and costly. So it is a good idea, again, if possible, to get these started early. In case there are any hiccups or issues. Under the current pilots, it is necessary to submit these documents upfront instead of the previous system where the documents could be submitted after the PR application was already submitted. So it's really important to get these done sooner rather than later. Similarly, correctly listing work history is really, really important. And this includes periods of part-time work. So if there was a temporary period where a caregiver was working part-time, it's important to note that because otherwise, there could be a situation where potentially someone has applied with less than 24 months work experience, and so you really want to refer people to get legal advice to make sure that they meet the eligibility requirements before they apply. And another thing I wanted to just note as well is that one of the questions that we get not infrequently is whether it is how to deal with unauthorized work. So it is a requirement to correctly list one's work history, including unauthorized work. And so not doing so can actually lead to potentially allegations of misrepresentation, which are very, very serious and more serious than the underlying unauthorized work issue. So if someone does have that concern, again, we really encourage you to refer your clients to our office for legal advice. And the last kind of couple of issues I wanted to highlight with respect to caregiver applications is that we do get often questions about marital status. So for instance, what happens if, when I came on my work permit, I said I was single, but I was actually in a common law relationship. This comes up relatively not infrequently, and again, these situations can definitely be dealt with as long as proper legal advice is given. So I highly encourage you to refer your clients to us if they need advice on this type of situation, and as well, just the issues around just making full disclosure in applications. So sometimes there are past refusals, or there may have been family members that were not declared on an initial work permit application, or there may be, criminality or criminal charges that have been made against the applicant or a family member. And so again, it's just really, really important to get legal advice, because sometimes people are afraid to disclose these things when in fact it may not actually impact the application in any way, but not disclosing them would impact the application. So really important that folks get correct legal advice about that. So again, we've just put up a document checklist here. This is not exhaustive, but this is just to give you a sense of what some of the documents that are required are. And again, we do offer PR workshops for the caregiver programs here at the Migrant Workers Center. So we would encourage you to refer your clients to us, and we will go over in detail what the documentary requirements are. The other thing I wanted to mention is that at Migrant Workers Center, we do offer PR application reviews for caregivers. So if someone has a complete application and they want it reviewed and checked for completeness, and the documents checked and the forms checked, we do offer that service. So folks can contact our office and make an appointment to meet with one of the legal advocates or lawyers in our office.
Alrighty, so next we're going to talk about a couple programs that are in the works and set out what they could provide and what we know now and what we may expect from them in the future. What's great about these is they do address this long-standing ask of NOC and NOC-D low-skilled permanent residence pathways that has been a huge political issue for anybody who's been following immigration policy and different party platforms. So the first program I'm going to look into is the Agri-Food Immigration Pilot. To apply for permanent residence through the Agri-Food Immigration Pilot, you need eligible Canadian work experience of 1 year, full-time work in the past 3 years in one of the eligible occupations within an eligible industry through the Temporary Foreign Worker Program. So we've listed here the essential industries, this eligible industries as of right now: meat product manufacturing, greenhouse, nursery, floriculture, mushroom production, animal production, excluding aquaculture. And then we have listed also the eligible NOC-D, C or D jobs with the caps per year. One of the important things are with prevailing wage. And for those who are not comfortable yet with Job Bank, I would strongly suggest spending a lot of time on Job Bank to figure out how wages work, because they're going to look carefully at ensuring that the wage is at or above the prevailing wage. Also, language is a huge issue. You're going to have to prove CLB4 and have at least equivalent of a Canadian high school diploma. So this may be a recommendation that's given to a lot of workers in these areas, is we need to focus on the language skills, and we need to get copies of the high school diploma and get educational credential assessments and the rest that likely will follow with these programs. You also have to prove that you have enough money to settle in Canada and support yourself and your family, unless you're already working in Canada with a valid work permit. There's going to be these annual limits and caps that I discussed, and starting in January 1st of each year, the applications are going to be processed on a first-come, first-served basis. So this is fun. We have a program that's going to start in March 2020 with a 3-year pilot. We know what some of the programs looks like, but we don't know the full details. So what I've done on this crystal ball slide, for those of you who are interested in following what the government is doing, is to look at both what we know and what we don't know. And especially on the what we don't know side, we definitely want to ask the question, will the eligible jobs change? And I know as advocates for many of us, if we do realize that there's a population or a subsection, an occupation that is not being covered, how do we advocate on their behalf to try and get them included as well? Also, how strictly will prevailing wage and genuineness of the job offer be examined? One of the things that Karen mentioned earlier with her BCPNP entry-level low-skilled program is that they look at employers who hire low-skilled workers in a different light. They do scrutinize their wage, they scrutinize the terms of their employment, they scrutinize the contract, and oftentimes these contracts and wages they can be in more precarious situations due to lack of knowledge from employers, lack of advice from employment lawyers, and so forth. So this is something to watch for carefully as we look at what this program looks like. So I would suggest that more so than in other areas, ensuring clients are legally supported, especially when the program is new, is going to be very important. So for this program, we know even less. It's the Municipal Nominee program. So we know that the government, and it's part of the Liberal government's platform for this past election, was that the immigration minister should focus on creating a municipal nomination program. So I've listed what we know and what we don't know, but we have some questions for sure about we know the impetus for this. The government wants migrants to move to smaller rural communities and municipalities and to alleviate pressure on larger metropolitan cities. And the idea is this will help build out areas of Canada that will require more investment, diversify communities, and so forth. And we know that low-skilled migrant opportunities for permanent residents will be available as part of this program. However, we are adding a municipal layer to an area where it's federal, provincial jurisdiction currently, and we already see these challenges between federal and provincial jurisdiction. So how will adding this municipal layer work? What kind of oversight will these third-party municipalities, chambers of commerce, labor councils be under? We know and we've seen in other programs where there are third parties that filter and they may have their own financial incentives, possible situations for which Juliana mentioned are like exploitation, contracts working behind employees' backs. So when we represent workers, we have to ensure that when there's a program that's new, that they're getting proper legal advice, that they're getting proper advice on what these the uncertainties, and that they do their due diligence before working with third parties. So that's we know at least 5,000 spaces are going to be available, and I do think that this program will be expanded because it seems to be a huge political and government focus right now.
Okay, I will now talk about the humanitarian and compassionate grounds and how migrant workers could apply for this. So let me first start by explaining how this program works. Now, applying for humanitarian and compassionate grounds is an exceptional measure. It is not simply another means of applying for permanent residency status in this country, and it's important to note that the inconvenience of returning to your home country is not enough. There must be compelling factors. Now, many migrant workers have experienced abuse, exploitation during recruitment, or during employment. So when you're applying for humanitarian and compassionate grounds, you have to satisfy the immigration officer that there are humanitarian and compassionate grounds for you to stay. So they will look at the best interests of the child, which looks at child's health and emotional well-being, the child's need for stability or safety, and education. It is also important to know that it is hard to get humanitarian and compassionate grounds. The approval rates are not very high. It is extremely important to get that legal advice and legal representation who can go through all of the legal requirements that you need. So whether you're collecting your work history, your English skills, or any psychological reports. So it's important to get that legal support who might be able to connect all the dots, prepare a really good file, because that's very important because you need to satisfy the immigration officer that you deserve to stay in this country. So what we do at UBC's Law Students Legal Advice Program is that we don't charge any money. It requires a lot of work. It requires hours and hours of preparation. but there are a huge number of students who are more than willing to assist migrant workers. They do it out of their goodness. They want to help migrant workers stay in this country. Let me give you an example. For a recent Humanitarian and Compassionate Grant file, we assisted a domestic violence survivor to document her story properly. We coordinated with various organizations with the types of letters that you need for an H&C file. And with the client's permission, we can reach out to the client's friends on the type of support letters that they could write. And we also might be able to provide draft letters that clients could write. So we'll work with them, sit with them, discuss the issues that they should talk about in the letters for their immigration file. We can also prepare country profiles for migrant workers. So each and every country has a unique set of socioeconomic problems, political problems. We'll write that and really fine-tune all the details, and then provide a comprehensive background about the conditions in a foreign country, so that the immigration officer has a much holistic picture of that particular file. We also talk to them about their personal stories, the conditions of their home country, and see what we can do. I also want to tell you that there are 2 stages of an H&C application, and if the first stage is approved, the applicants can get permission to work or study. Unlike a refugee application, there's generally no interviews. The decision is based on a written application. That's why it's important to have a very strong written application. I mean, they could ask you for an interview, but it's rare. That's why the application must be very strong, and so that you have all the issues and everything that must be in the file.
So we just wanted to highlight here some of the factors that officers are directed to consider in an H&C application. As Asithwa mentioned, like every case is unique, and so it's important for the client to get legal advice and assistance with developing their particular application. These factors are not exhaustive. Officers have discretion to consider any relevant factor. They are required by law to consider the best interests of any child affected by the decision. So it's really, really important to carefully document, provide evidence of the impact on children that would be impacted by the removal of a parent. So on that note, officers are required to be alert, alive, and sensitive to the best interests of children. And it's recognized that children will rarely, if ever, be deserving of hardship and may experience greater hardship than adults in similar circumstances. So these are some of the factors that the officers will look at when examining the situation of children. It's important to really consider all angles and document all angles and explain why the only solution that serves the child's best interests is the solution of the child remaining in Canada with the parent, or if the child is overseas, why the best solution is for the parent to remain in Canada. And I also, I just wanted to note that that's not an uncommon situation for migrant workers where they have children overseas. And in these situations, it is possible to develop an argument around the best interests of the children that looks at the situation of the children in the home country and the importance of the parent being able to remain in Canada to offer financial support, for instance. So looking at H&Cs for migrant workers specifically, it's really important, and I've just highlighted here some of the main themes to consider that a law student or a legal advocate or lawyer can assist the client in developing with their application. So one of the first questions that I try to answer and really develop is, why does this client require humanitarian and compassionate relief? Why do they need an exception from the general criteria that applies to everyone? For instance, have they experienced exploitation or abuse during the process of their recruitment to come to Canada, or during their employment in Canada that has prevented them from accessing a pathway to permanent residence? For instance, did they pay a recruitment fee in their home country on the promise of a pathway to PR, only to find out that the job that they were promised and that pathway to permanent residence never existed? These are kind of some of the questions that I try to look at and present to the officer as circumstances which would compel an officer to try to offer relief and an exemption to the client. We also want to try to demonstrate their establishment in Canada. As Asitwa mentioned, we want to do that through extensive documentation, such as support letters from friends, coworkers, and community members, showing the integration of the individual into their community here in Canada. We want to document their community involvement and their work history. If they're not working, we want to document and show willingness to work and efforts to improve employability, for instance, through job training, through English classes, etc. And then, as Asitwa mentioned, we want to look at why would it impose a hardship for the individual to return to their home country? You know, what are the socioeconomic conditions in the country? Would the client experience gender discrimination or violence? What kind of supports would be available to them? Particularly if they have experienced exploitation and abuse in Canada, they may have a support network here in Canada that's helping them to heal, and separating them from that support network is going to impose a significant hardship. And here's where, you know, really, I think that settlement workers and community support organizations have an incredibly important role to play in assisting the client to demonstrate, you know, not only their integration into the community, but also to ensure that that client is supported and connected with community resources, and you know, medical support where required. So if you're working with clients in this situation, it's great if you can connect them with those supports, as you know, and encourage them to seek out support where they need it. For instance, providing reports from counselors and medical professionals documenting things like post-traumatic stress disorder, anxiety, or depression can be extremely helpful in demonstrating to the officer who's going to review their application the particular hardship that this individual is going to face if they're forced to leave Canada. And then, of course, as we've already discussed, just really carefully and robustly documenting the situation of children and examining that from all angles to show why the child would be best served by their parent remaining in Canada. So here we have another theoretical case example. So in this example, Mary is a citizen of the Philippines with 3 children. She was promised a food processing job in Canada by a recruiter and was told that she could get permanent residency. She took out a loan to pay the recruiter a substantial fee for the job, but upon arriving in Canada, she learned that the job did not exist. Instead, she was forced to work for a relative of the recruiter as a housekeeper to pay off the debt while working long hours for very little to no pay. However, she doesn't want to return to her home country. Her children are relying on her for financial support, and she previously faced domestic violence in her home country and couldn't get any help from the authorities. So she hopes to start a new life in Canada with help from a community organization. She has left her employment and is now volunteering, taking English classes and job training courses, and seeing a counselor regularly. So in this situation, the question is this a good candidate to file a humanitarian and compassionate application? And of course, we don't have all the facts, but I would say generally speaking, yes. This is, just highlighting some of the factors that we've talked about. This is someone who's experienced abuse and exploitation in Canada, and that's, an exceptional circumstance that may be deserving of relief. This is someone who's experienced, an extreme level of exploitation, rising potentially to the level of trafficking. There are reasons why Mary cannot return to her home country, which include, both previously being a victim of family violence, and as Estefan mentioned, that's, can be a factor in many cases, and in particular as well, the socioeconomic conditions in her home country are relevant as well. She has children who rely on her for financial support. And we have evidence of her establishment and her willingness to work once she has authorization to do so. I would say this is a good set of facts, and we would, if this client came to us, we would want to help her, really carefully document everything, including the abuse that she experienced in Canada and from the recruiters. We would want to help gather letters of support, letters from her counselor that she's seeing, and possibly even a psychological report. We want to think about the timing. So, we don't know exactly how long she's been in Canada, and that's something that we'll talk about in a moment, just in terms of, how do you balance the risk of removal with the need to show a high level of establishment. So that's something that we would want to caution her and carefully, discuss with her, especially if and we can assume that most likely Mary is out of status. And that's a really important point that I wanted to highlight as well, that the humanitarian and compassionate application is available to people who are out of status, and don't have any legal status, and may be inadmissible to Canada for variety of reasons. So again, these applications are very complex, and so it's really important to get legal advice to one's particular situation before making any application. But with that said, I think based on what we know here, this would be a good case to refer, potentially to the Law Students Legal Advice Program or another agency or lawyer potentially to assist her. So we just wanted to very, very quickly sort of walk you through the process of submitting an application in case you are supporting clients who are going through this process. Usually most organizations will begin with an intake where they review the facts and try to gather as much information from the client. Then the forms need to be prepared, and supporting documentation needs to be gathered. And this is where I think, settlement agencies and support organizations can really make a big difference in assisting clients in gathering and sort of organizing the voluminous amount of documentation that is involved. It really does assist the legal representative if the client has support in the community to help them, go to appointments and help them, reach out to people and make lists of who they're going to ask for support letters from, et cetera, et cetera. So those are some of the things that that definitely it's helpful to have support on. And then the client's personal statement or affidavit will be, the legal rep will work with them to develop that. And then the application is submitted. And then the last thing I wanted to highlight is that it is really, really important that clients periodically are updating their applications with support from their legal rep to let IRCC know about any updates in their situation. H&C applications it's a very lengthy processing time. They can take up to, more than a year or for a first stage decision to be made. So it is important that, situations can change, governments can change, civil wars can break out. So it is important for the individual to be keeping their application updated with the most current information. And finally, we just wanted to note a few best practices and pitfalls. So at the risk of sounding like a broken record, it's really important to get legal advice and make a plan, because these applications do take a very long time to process, and there's a lot of thinking and planning that goes into them. It's really great idea to get connected with a legal representative early on in the process, as it may take several months to prepare the supporting documentation and prepare the client's narrative. And in certain situations, it may be advisable to file a basic application just to meet the completeness requirements first, so that it's in process, and then update it later with documentation. So again, these are questions that the legal rep is going to go over with the client. You want to, again, make sure that the client is connected with community resources and is well supported, as this is not only going to help the client, to heal from whatever they've experienced, or enhance their establishment in Canada. It's also going to help, support the documenting a strong application. Clients may be hesitant to see a counselor. It may be not something that they have heard about, or it may not be something that they feel comfortable with. And I think, again, that settlement, support, settlement workers or support organizations can make a difference there in sort of helping clients to see what the benefits might be of engaging with a counselor, therapist, or medical professionals. And lastly, we just wanted to address a few kind of common questions that do come up in the context of H&Cs. So one of them is timing. When do you apply? How do you balance the risk between the risk of potential removal if your client is out of status and potentially inadmissible, with the trade-off that if you apply too early, the client might not have super strong evidence of establishment. So that's a really careful balance that you're going to want to, that the client is going to want to have advice on. And this may depend, for instance, on where the client comes from, what are the situation in the home country, these types of things. Do they have a viable pre-removal risk assessment? Do they have a fear of returning to their home country that's based on refugee-related factors? Because that could potentially stay removal and buy a little bit of time as those applications are decided concurrently. So that's something that the person's going to want to consider. Another question that we get is around working while awaiting first stage approval. Will, did you want to talk about that?
Working while waiting for stage approval.
Yeah.
Oh, yes, okay.
Because once first stage approval is granted, a client can obtain a work permit, yes, and can obtain medical coverage, yes, which is obviously can be super, super important. But if you're waiting for that, how do you balance the need to show economic establishment and the need to show economic contributions with the fact that one is not authorized? And I mean, of course, we as legal advocates, have to advise our clients that, they're not, without work authorization, they're not, legally allowed to work. But it is a question that we do get.
Yeah. And I think it goes to highlight with these assessments, first of all, the level of discretion. You see cases where migrants who are not following the rules and are working without authorization then get commented for doing that in a negative light as a negative factor in the assessment. But then in other cases, because they're not doing that, that's a negative factor as well. Mm-hmm. So what I now advise on these issues, again, within the context of I cannot advise someone to directly break the law, is you have to do what's best for yourself and your family in the context of what you want in Canada, which is ultimately permanent residence on the basis of humanitarian compassionate considerations. In some cases, that may involve an individual working without authorization in order to support their family, in order to further their possibility of fitting the requirements. Mm-hmm. Yeah.
Right, because with an H&C application, I mean, you're starting from the premise that this is somebody who doesn't meet the requirements to immigrate and may be inadmissible. So, it is a fact that some people will engage in unauthorized work, and that's just another factor that has to be knitted into the broader application as it's assessed holistically. One thing that I do advise folks as well, if they're worried, you know, about showing their economic establishment while lacking authorization to work, is to, you know, show evidence of their efforts to improve their skills and enhance their employability. So that can be job trainings, obtaining, you know, a food safe certificate, or attending a trade, you know, some kind of, you know, basic training on you know, skills in the workplace. Those, you know, can go a long way, and towards showing that the person is, you know, respecting Canadian law and respecting the fact that they're not authorized to work, but they are eager to do so, and they are taking all the steps that they can to prepare themselves if they do eventually receive authorization.
And in those cases, reference letters from possible future employers or individuals who are supporting them would be great. One of the things that is important to flag here is that a lot of this is a creature. The statute governs it, but there's a lot of policy in between that could change. For example, if they see an uptake in humanitarian compassionate grounds, they may start rethinking how long they take on first stage processing, whether after first stage processing they even grant deferrals of removal. These are a lot of things that can change down the road. So it's also really important to keep updated on what the local conditions are, how long it's taking, what's going on with enforcement while this is happening, how long are PRAS, pre-removal risk assessments that Juliana talked about, how long are they taking to process if they're being done concurrently. CBSA may want to try and enforce removals more quickly on individuals, not giving them a chance to wait it out. And once these applications go overseas to visa offices, the chance of this becoming successful will become much lower, because the individuals have to start establishing and connecting with other countries, which makes a lot of this assessment more difficult. So that's the overall consequence of a lot of this. Yeah. Okay.
Just here, I'm not going to review this slide, but just to leave you with some sort of basic information about if you do have a client who has potential H&C, where you can refer them. It's a good idea to check and see if the client qualifies for legal aid. They may be, if they meet the minimum income, you know, the low income requirement, and if they have a meritorious case, they may be able to get a certificate for legal aid to fund a lawyer for them. And if for any reason they don't qualify for legal aid, then you can consider contacting the Law Students Legal Advice Program for assistance from a law student under the supervision of a lawyer.
Wonderful. So we want to take at least 15 minutes for questions. So I'm going to just briefly summarize a few takeaways from our presentation and things that we've been seeing writ large generally that I think it's important to discuss. The first is on the intersection between the challenges that immigration poses for low-skilled workers versus other issues that migrant workers are dealing with. One of the main ones that I've been seeing recently is computer literacy and challenges with documentation and online forms. Immigration has put a huge emphasis now on moving processes online for many different temporary extensions and so forth. Doing immigration forms for an H&C or for some of these programs may be the first time that the migrants actually worked on their own application forms. Many times they were done by agents or other individuals on their behalf. So it's really important first to get a history through access to information requests of all the documents ever submitted. And second, it is important to walk through these forms and spend some time and seek legal advice, as Juliana said, on these issues. Another one is language barriers and the cost of interpretation. Much of the documentation, such as statements and affidavits and country condition proofs from back home, may not be in the English or French language and therefore require certified translation. One of the things I've learned is that oftentimes some of these the prices of these services are actually cheaper back in the country where individuals are coming from, or or through friend connections. Try and find out those resources and see if you can try and provide the service at as low cost as possible, because these can rack up and in many cases can be more expensive than legal fees and other things that individuals are dealing with. Status issues are another huge problem. Juliana alluded to it. When you're applying for something such as H&C, how are you extending your status temporarily in the interim? Do you continue to extend your status? What happens when immigration sends you a letter and says you have to leave Canada immediately? Be very cautious about these issues. Be very cautious also of the call center providing inaccurate advice for individuals to leave Canada right away, or that they have no status. Many times they don't even have the full picture. So this is another one where you want to refer to legal assistance. Finally, number 4, relationships are key. Individuals who come to you may have common law partners who they lived with for 1 year in a conjugal relationship that they may think are just their boyfriend or girlfriend. They may have Canadian citizen spouses or other individuals. They may have children. These are all things that you should flag. There may be other permanent residence options for out-of-status migrant workers. For example, there's a public policy under Appendix A for sponsorship inside Canada of spouses, where one spouse could be out of status for reasons of unauthorized work or for loss of status. Or there may be issues with dependents that have not been disclosed previously, as Juliana mentioned, that commonly comes in the caregiver context as well. Make sure you flag these issues because these could come up later in the permanent residence process. And we just want to give a very, very strong warning on misrepresentation. And this is where individuals, I mean, even in our practice as lawyers and consultants and law students are aware, but individuals who are helping just on good faith nature need to be aware of as well. There is a strict 5-year bar for misrepresentation. There's no discretion as to it's 1 year, 4 year, 5. It's all 5 years. And many times they come from mistakes. They come from sloppy mistakes. They come from and it also has effects on family members and dependents as well. It's a very, very low threshold test. Was it misrepresentation, and was it material so that it can induce an error in the administration of the IRPA? Essentially, if an officer's assessment would have been different, or they would have looked at something different, they could have put it to a secondary review instead of a primary review. That's enough to make it material. So the courts themselves have upheld that this is a very broad provision. Intent is not required, and the honest mistake exception is very limited. So unless you really have a migrant worker who's talked to their employer, or to talk to the advisor, or try to intercept before it was even decided or looked at, it's very hard to try and claim after the fact that this was an honest mistake. And we're seeing government, Canada Border Service Agency, IRCC, increase their pursuit here, especially on application form issues. Have you been previously refused? Do you have medical issues? Have you ever been part of a government organization? Have you ever been arrested or detained? These are questions that often lead to some interpretation, and especially if you're not very fluent with the English language, they become even more easier to make mistakes on. So please be aware of this and look into it. And finally, what can I help my clients with? Juliana, if you want to jump in on this one as well, it's really important. No IRPA Section 91 in terms of who can practice for a fee. Fee includes indirect compensation. So this is really important to inform your staff on. And I'm talking more than just like receiving gifts in exchange for doing work, but there could be some indirect way by which you are actually directly compensated for helping a certain individual, and you're helping them with immigration. So you have to be careful if you're just a caseworker and you're assisting for a fee, including indirect compensation. It's so important, Juliana's mentioned it many times, as is Karen and Stidwa, refer out for legal advice. We have provided a resource list that I won't go through in detail, but look at that and contact individuals where there are legal issues or where you flag problems. Gathering documents, that's such a key role in providing assistance. Paperwork and the number of forms and the different verifications that need to be done. This is all things that you can help them with in the front end to put together that package. But again, going with that previous advice, make sure to refer out where there is a legal issue or to get that second legal opinion if you need it. Gathering information, helping prepare draft forms. We're definitely sounding like a broken record now, but legal service providers should review all the forms, make sure that misrepresentations aren't happening, that there isn't omissions, that this isn't going to be delayed because you forgot to submit something or it's sent back. Connect clients with social support. Maybe actually, Juliana, you can add something here because you do this quite often in your work, and I was really inspired by the way that you send clients out to different services?
Yeah, so at Migrant Workers Center, for instance, we work quite closely with a lot of different social support agencies, such as like the Salvation Army's New Hope Outreach program, that are just absolutely wonderful in terms of the work that they do to connect clients to resources that are available to support them. And we've seen the impact with our clients in terms of how they have been able to heal and get support and experience, especially after experiencing very serious forms of exploitation, that they've been able to heal from those experiences and regain their dignity and regain their sense of self through the help from community agencies. So those are really the work that your agencies do is so important, and it's very much appreciated by the legal service providers. And in addition to that, just providing access to, clients are often have a lot of difficulty navigating complex systems in an unfamiliar, a new country. And so just that navigation with respect to, how to register for a language class, how to find a language class if you're not eligible for the, the government funded ones, locating, conversation groups, locating how to find a doctor. These are all super important services that your agencies provide, and we're very grateful for it.
Yeah, and in terms of community-based resources, we are, I would say the state of affairs right now is imperfect. There are some good resources and that are being shared around different professionals, but we haven't quite yet found a way to centralize these. But this is something that many of our organizations together and through collaboration and through presentations like this, we're gathering feedback and we're working on creating community-based resources so that clients are able to know what needs to be in a support letter, what type of documentation would help their case, what are the common pitfalls. But just by spreading the word on this and being like, you should talk to someone from Migrant Workers Center or LSLAP before you sign off on this form or before you submit this, that itself is such a community resource, and that's the thing that we really want to emphasize on this presentation. So to conclude, we've provided a list of resources and referral options. These are mostly local based. I know actually Stip was telling us one of his colleagues is maybe on this call from Winnipeg. So we might know that there may be national, and in your own cities, I encourage you to look for these type of resource lists. But there are several referral options locally in the greater Vancouver in BC. And we all have points of contact with each other, and we're working on our referrals within each other as well. Hopefully to cover your range of issues relating to low-skilled migrants seeking permanent residence. So subject to, or no, that's like what I say.
One thing I wanted to add as well, for folks who are listening from other areas of British Columbia, outside of the greater Vancouver area, a lot of these resources are based in the Lower Mainland, but I did want to let you know that, for instance, at least with Migrant Workers Center, we have a province-wide mandate, so we can assist migrant workers anywhere in the province, and we do assist migrant workers that are up north or in other communities that are remote. We can work with folks over the phone, over electronically, and this is where again, help from support agencies is really critical. So just to let you know that if your clients are not in the greater Vancouver area, they may still be eligible for services. So it's just important to call and find out about the eligibility for intake.
Yep. And so we just add for LSLAP, give it a plug as I'm the supervising lawyer. We have started now an immigration-specific clinic on Monday nights. It's every other Monday at Mount Pleasant Neighborhood House, where we just focus on immigration. I'm there in person providing assistance to the students as they help individuals, and we're working on a lot of H&C applications and temporary resident cases right now. So feel free to send those cases our way. And if any of you need more presentations or more specific presentations, I know we kind of give an overview today. There's a lot of issues that can be fleshed out in its own presentation. We're happy to take that feedback in and trying to carve our resources accordingly. But let's give at least 10, maybe we can buy another 5 minutes for questions, and we will try and address what we can. Again, try not to keep them case specific. I think we're more trying to provide general guidance that can help you moving forward. and thinking forward on what low skilled migrant worker programs and permanent residence options can look like.
Great, thank you so much, Will, Karen, Astitwa, and Juliana for your presentation. It was really great to get that overview, and we do have quite a few questions that have come in, and I'll be sharing these with you afterwards. So, and some of them are a little bit case specific, so that maybe you can reach out to some of those individuals. But one of the questions that's come up is it mandatory for an H&C application to be done by a lawyer? And if it's possible to gather the documents yourself?
Yeah, so I mean, I would say that it is certainly not mandatory for an H&C application to be prepared by a lawyer, but what we're kind of recommending is that it's a good idea to get legal advice before submitting the application. And certainly collecting documents is something that folks can do by themselves and is a huge help for their legal rep, especially if, you know, we're talking about a volunteer law student who is, you know, doing this work, you know, on a volunteer basis, or, you know, a community legal clinic whose resources are stretched. We really appreciate when clients do take initiative to gather documents and are prepared, you know, and maybe have some of their documents already organized and together when they come and see us, and then we can get a better sense and more easily understand the situation.
Yeah. Do you want to?
Yeah, just to add to that, I mean, it's not mandatory, but it's really strongly recommended. And from what I can see from my personal experience is that whenever they're trying to do it on their own, very few applicants meet all the requirements that they need to fulfill. So if you seek a lawyer or a volunteer lawyer, they can, or like a volunteer law student, they'll give you a long checklist, be like, hey, these are the documents that you need to collect. This is how you can organize the file. These are some of the issues that you must talk. So let's say reaching out to a psychologist, because there are community organizations where you can go in Vancouver who will do that for free. They'll write a letter on whether you or your child has PTSD or anxiety or depression and other things. So collecting those documents can be really important. So especially in Vancouver, in BC, if you have those community resources and support for free, then you should definitely try to seek that support.
Yeah. I want to add just one more point, and this hopefully will help some individuals avoid fraudulent and unscrupulous individuals who assist them. One of the reasons I find a lot of lawyers are hesitant to jump in is perhaps this unbundled nature of sometimes assisting on discrete questions or setting out things without completing the whole matter. But on the flip side, you have a lot of consultants, many of them unscrupulous, who will say, you know what, we'll do it all for you. Pay us a set amount of fees, give us all your documents, and we'll submit it on your behalf. Whenever someone says we're going to submit something on your behalf, the red flag should go off immediately. This is a type of work that really requires a lot of client and advisor interaction all the way through. And if someone is just compiling a list of documents and sending it off without addressing the legal issues, without addressing submissions on your behalf, you are paying them essentially to put a combination of paper together and send it off. You're not really paying for that strategic advice on whether it's right to file now, what are the challenges in your application, how to address the factors. So be very cautious of working with individuals who say that they're just going to gather your documents and send them off without you seeing it, especially.
Okay, perfect. Thank you so much. And we've had the request to go back to the slide with the referral option. So we'll leave that up for a little bit, and then we'll go back to your contact information slide. But please also do note that we will be sharing this out, and it will be posted up on the Migrant Worker Hub website. And you can also download it by going to the handout section on the right-hand side in the GoToWebinar control panel. So there's some different options there for you to get that information. But one question that's come up a few times is in regards to interpretation and translation in regards to filing applications. Should an individual be bringing their own interpreter with them, or is that something that you're providing? There was just some clarity needed.
You want to start maybe with the experiences?
Sure,
and we'll
yeah, it's a
talk about it.
great question, and I think, you know, and I'm thankful for the folks that have raised it, because it's a bit of something that comes up all the time in our practice, is the sort of pitfalls of dealing with you know, interpretation. So I mean, I do encourage folks to bring their own, you know, if they do have someone in their life that they can have as an interpreter, to sort of, you know, guide through the, you know, basic type of things. But if it's something that, you know, involves more complex legal issues, or if we're making really important decisions, and I really want to make sure that my client understands you know, what is going on and what are the risks, and is making an informed decision, I may say, you know, we need to get a certified interpreter for this particular meeting, just because there are, you know, there are nuances, and you know, of course, if I don't speak the language, I don't know that, you know, it's difficult for me to assess whether or not my client is really understanding. And so sometimes, you know, I am going to want to use a certified interpreter, but I'll always be cognizant of, you know, of the fact that, you know, it can be costly. We do have, our organization has some funding for victims of exploitation and abuse, to provide free interpretation and free translation services. So hopefully that's not a barrier. Yeah, I mean, the thing that I would just add is that as legal reps, we have to be very vigilant, you know, as well, in ensuring that the individual who, if someone is bringing their own interpreter, that person is trusted, and that the person feels comfortable speaking in front of that interpreter. You know, I've certainly had experiences where someone comes with somebody who, you know, who's interpreting for them, but then it becomes obvious after a few meetings that they don't really feel comfortable speaking freely in front of this friend or family member, and then it's important to, if there's any indication of that, to get somebody else in there. So that's sort of how I would approach that.
And I think Juliana alluded to it, but the vetting is really important too. Before I talk about anything confidential, I always ask the other individual in the room, what is your relationship? How did you meet? What is your role here? Because it's not uncommon for a family friend who is actually a former consultant of the individual, or even, you know, in the context of work, even a former, you know, an employer who isn't willing to go certain ways that may be in your client's best interests, can very much complicate things. There are a lot of firms that have language skills, though, and I think it's sometimes we forget that even in all our law firms, many of us have individuals who speak multiple languages in LSLAP and in migrant workers, as Juliana mentioned. Asking the organization if they have that language support, and what, if any, additional cost that would provide on the services, if there is a cost, is always a good question to ask, and to be diligent in this work. Review all the translations too. Translations aren't always perfect. That's another tip is we always get often bad translations especially from the ones I was mentioning from different countries, and a missing comma or bad translations can really affect when officers highlight those bad translations as part of credibility mistakes or other things like that.
And that's one area that, as settlement workers, I think there's potentially a really crucial role to play, you know, in, again, you know, just supporting the clients, you know, maybe sitting with them, you know, to check over translations, make sure they're accurate, you know, because I would assume that, you know, you might be engaging with them in their native language. And as well, you know, I've had settlement workers accompany clients to meetings and serve as translators. So that's also a really helpful support.
Perfect. Thank you for highlighting the various different areas around that complex topic, particularly in ways how settlement workers can support, and really just to be mindful of interpretation and translation. One question that's come up a few times is, can a person be deported during the wait time when they're waiting for their humanitarian and compassionate application to be processed?
Excellent question. The answer is yes. While the person is, before a decision on first stage approval has been made, there is no stay on removal automatically. Now, there are some steps that can be taken that would stay removal, or at least could sort of defer removal. So again, it's important for that person to get advice about their options, and a lot depends on where they're coming from, what type of concerns they have about returning to their home country. Are they a victim of trafficking in persons that could allow them to make an application based on that? So there are a number of questions to consider, but something that I will note that once a decision of first stage approval has been made, then that the person's removal is stayed. And that's by operation of regulation. So once that decision on first stage approval has been made, they are safe.
Yeah, and another thing to flag on that too is when you hear of issues with admissibility, or Canada Border Service Agency comes up in conversation, or criminal matters come up in conversation, those should be flagged to like, this individual needs legal advice, because these things can run concurrently. And oftentimes, CBSA, for example, if they pursue an admissibility matter against an individual, that changes the possibility, maybe even access to the humanitarian compassionate grounds option. We didn't talk about it in full, but there are several individuals who are excluded from applying, who aren't able to apply, failed refugee claimants who, because they don't have a medical reason, argument, or a best interest of the child, are barred for 12 months from applying. So there's a lot of bars and a lot of exclusions that are very important to navigate through as well. And the worst case would be to put in a whole application and find out that you're actually not eligible to make one. So those are things to be very aware of. And immigration has good websites on that.
Perfect. Thank you so much. And so I do want to acknowledge that we are at the end of the time of the webinar. And so we'll be able to do one more question. And so this is a question in terms of when should somebody apply in terms of applying for an H&C application, particularly as they've applied for one and it was denied. And so if their circumstances have changed, should they be applying again?
So in these cases, it's first of all really important to get a copy through access information request, or if they have their own copy, and look at what was previously submitted. When you have a previous refusal, there is that notion that there may have been something short on that application. The change of circumstance may or may not cover that concern, but ultimately it also could be some concerns with that application that flow through to your new one. So knowing what was submitted before and trying to address maybe things that weren't fully explained on the last one, or erroneously explained, would be a good starting point. And second is to very much highlight that information. In these applications, things such as affidavits, legally sworn documents are very important. And there may even be needs to eventually go to court on some of these. You'll see some officers who are just insistent on refusing applications, and especially if individuals have multiple applications. So that's another area where you want to seek some legal advice. And I know the Migrant Worker Center offers it. LSLAP, we can help refer and get you to right space, but you may need to challenge that decision as well if they're on a legal ground just stopping you from making this from approving. But keep applying. There's some people who apply 2 or 3 times and get it on their 3rd or 4th attempt.
Yeah, absolutely. And I will say, yeah, if you do encounter clients that have gotten a refusal on any kind of application, whether it's H&C or a caregiver application, do feel free to refer them to us at the Migrant Worker Center. We do offer representation in certain judicial review applications. So even if you do get a refusal, it's not necessarily the end of the road for that client, as there may have been errors in the decision-making process. So it's just really important. And the timelines are very fast. Certain documents have to be filed in court within a matter of pretty much days after receiving the refusal. So timely referrals are really, really, really key.
Perfect. Thank you so much. And I'd just like to say thank you again to Will, Karen, Asitwa, and Juliana for your presentation, for answering all the questions. We will be sending out the presentation following today's events. And so if your question didn't get asked, or if you still have further questions, please also feel free to reach out to our speakers, as they provided their contact information in the slides. And so I just want to say, as I mentioned before, that this webinar is being recorded, and the recording will be posted in a few days on the migrantworkerhub.ca website. And so there's also a website where you can go and sign up and receive emails. And so if you have any questions, please feel free to send them to migrantworkerhub@amssa.org. And once again, just want to say thank you so much for everyone for joining today's event and for sending in your questions and for taking part in all the polls. We will be emailing participants an online evaluation form following the webinar, and so please take time to fill it out. Your feedback is really important to us as it helps us guide and plan for future events and trainings. And a special thank you again to our speaker team for giving us their time and for sharing their valuable knowledge and experience. And thank you to the AMSSA team today for supporting today's webinar. And you'll also see an email address for Alejandra Paramo, our Migrant Worker Support Coordinator, on the screen, aparamo@amssa.org. So please feel free to email Alejandra and seek support from her. And just a final thank you once more to the Government of Canada. We would like to thank the Government of Canada's Migrant Worker Support Network for funding today's event. So thank you so much to everyone. Hope you all have a great day. Bye-bye.